Senior counsel, you need to raise your voice.
Yeah, I don't know. Can you be given a microphone?
Oh, yes. The entire matter, if I may use this word, is very sensitive to the entire nation. And it's a proper that the court is not misunderstood in any way by granting the order. Let us just proceed and petition to have the appeals disposed of. And I believe that we can do so before the end of the month.
But senior counsel, without making any determination, if the court were to allow some kind of interim orders with respect to IEBC, but preserving the sanctity of the proceedings, so that IEBC does not touch on anything to do with the matters in controversy, but it can continue to function insofar as the arrangements for the pending by-elections are concerned, and whatever other duties it's doing, anything that is not touching on the merits or otherwise of the appeal. Would you be prejudiced? Your client be prejudiced in any way?
This is why the perception. This is perception that's troubling my own mind. This is perception to the rest of the Kenyans and so on.
Perception is yes, important, but it's neither here nor there. It's difficult to really judge the correct view of public perception. But okay, we'll deal with that. Thank you, counsel. Sorry, just hold on. Sorry, just yes. Yes.
My ladies and my lord, with your very kind permission, the order which the IBC takes umbrage with in judgment is order number 10, the effect of which was to state that the IBC did not have quorum to prepare for the referendum, to verify signatures in support of the BBI bill. It's quite unfortunate that by the time the judges of the High Court completed their deliberations, it was almost midnight. That is when they issued that order. But I believe the order may have been issued without taking into account a previous decision by Justice Okwan to the effect that the full quorum of the IBC is not required for purposes of conducting the day-to-day activities of the Secretariat or for purposes of preparing for by-elections. Now, if we were to take into account that fact, it will become manifest that the anxiety on the part of my two learned colleagues is really not imminent. And with that, then we may clear the deck so that we go and proceed on the other remaining issues.
All right, thank you. We hear you. We will make some directions. Thank you. Now, Mr. Dudley, yes? Sorry?
May I speak on the question of timing?
Yes, actually I was coming to that, but thank you. On the issue of time, so that you speak, I heard from senior counsel that 7 days would be sufficient to do to put in your respective submissions. If that is for the appellants, and taking 7 days also for the respondents, would there be a need for a limited period like 2 days to make a response to that? Yes. 2 days or 3 days? 2 days. So 7, then 7 and 2. 3. 773. Okay. 773. That's about 14 plus 3, 17 days. Okay. That is okay. The next, yeah.
On the question of time, my colleagues and the court, I think, are a little bit too optimistic, my lord.
Yes.
Because we've been served with 3,000 pages by the Attorney General, and my good friend Mr. Coleman has also served another 3,000 pages. Mr. Bongo as well. Those are about 9,000 pages, my lord. and we are entitled to file cause appeals and grounds of affirmation. So that's time we should first of all set aside, and we're requesting for some 21 days. This is a 321-page judgment report, and it's one of the most significant issues that this court is developing. So we can expedite it, yes, but let us not push it at breakneck speed, which does injustice, instead of doing justice to the country.
So what's your suggestion, Council?
My Lord, I'm requesting for 21 days for the respondents to look at the appeals and raise those appeals and also seek to affirm the judgment. Then parties can have maybe another 21 days for insight to file submissions, so that we just do justice to the country. Thank you. And on the issue of Mr. Kanjaba, which is still hanging around, Rule 75 is why anyone can file a notice of appeal, but it does not grant direct access to a matter. Because we need to know what stake Mr. Kanjaba seeks to raise in the matter. And so we request the court to direct him and a formal application, so that even if we consent to it, we know what we are consenting.
All right.
Thank you.
Now, before you sit down, Council, don't you think 21 days would be too long a time? Even in the presidential election petition, we hardly have that kind of time being granted. I am sure from the date this judgment was delivered, even before you were served with the record of appeal, you were interacting with the issues, and therefore you are able to work within a shorter period of time. Perhaps 10, but 21 seems inordinately too long.
What could we do with 14? Half the period that we ordinarily have in history, instead of the 30 that the rules give us.
Mr. Mangi, then Mr. Dr. Tiankoli.
My Lord, even in the High Court, which that is when we are primarily involved in the arguments, the timeline that was given was 14 days. It is only us who are allowed extra time because our response to the petitions spread across all the petitions. But all the parties had to do 14 days, and that was in the primary arguments. As your Lordship has said, everybody has interacted with this document. There may be many, but nobody is seeing them for the first time. And we are not bringing any primary review arguments before your Lordships. So 7 days, I think we would be the one who would be more worried about the timeline, because it is us who's presenting the case. And we are saying that we do not think we'll be introducing anything much new, just be reviewing the arguments that were there in the High Court. So 7 days is perfect for
maybe the appellants, you have already done what you needed to do, like filing the appeals, and you have already prepared everything. Could it be that the respondents require just a little bit more time to look at the papers that you have filed, like 10 days or 14 days? I take it that, for example, senior counsel, have you already filed your appeal?
My Lord, we have filed our appeal.
Yes.
And it has to be remembered that this was a record of the High Court in which all parties participated, and they had all the documents. And the appeals are the same record for each of the appeals, so they are not separate records for each of the appeals, thereby making 9,000 pages.
So indeed what you will be doing is just to prepare the submissions.
Yes, all we are doing is preparing for submission on a case where each party participated in the High Court and they accepted all documents to be filed.
All right, Dr. Giancolo?
So if we begin from that, my Lord, then we proceed on the basis that in presidential elections, which are participating, we are given 14 days to prepare a petition and have the case heard and counted. And parties are able to do it. When I did the presidential election, I had 12,000 pages, 9,000 of which were rejected.
All right, thank you. Dr. Giancolo?
My Lord, I think the issue that is not coming out clearly issue of fairness and evenness. This judgment being appealed was issued on the 13th May. The respondents took up to only 2 days ago to manage to assemble the issue of fairness and evenness. This judgment being appealed was issued on the 13th May. The respondents took up to only 2 days ago to manage to assemble their records of appeal and serve. They have already had about 17, 18 days. So as we speak, they are hesitant because it is them who are minded to appeal, and therefore it is them who have the incentive up to that point the appeal was being filed. So it is not worth too much to suggest that if only for purposes of evenness. If then, with all the interest they have had in seeing this BBI go through, have taken about 20 days to file this appeal, they have had a head start of 20 days. So when we ask for 21 days, it may sound initially like we just want to wind down the clock. But it's actually a matter of giving every party a fair, not necessarily a very generous, but a fair opportunity to examine all those documents and be able to make a reasoned position on their appeal. My Lord, even if we take it just one record, running 9,000 pages, and you give me 7 days or 14 days, you are suggesting I can read 1,000 pages more a day, and besides reading, you do the drafting, the legal research required, and what. It's just not humanly practical. And I appreciate, we agree without any reservation that this case is extremely urgent, but it doesn't mean the requirement of fairness being sacrificed at the altar of expedition.
I hear you, Counsel.
Petitions and affidavits that they filed in the Superior Court. Part of that record is their own submissions. And you know, in the High Court, we have more than 10 petitions. Part of that record, their own submissions that they filed in the House. Part of that record are the authorities, which they submitted to the High Court. So this emphasis on the length of record is record which primarily was generated by the respondents. So they do not really to go back and read that stuff that is material that they're familiar with. We are trying to get a consensus, and that's why we are agreed to abandon or withdraw the applications so that we can get this matter expeditiously. So, my Lord, I'll plead that instead of going back and forth, that you give your directions. And even for us, filing of the appeal was delayed, not really, or not delayed, but it was when it was filed, because we were waiting for the document and the decree. We could have filed it even within 7 days. But I think we got the decree on Monday. That's when we got it. Otherwise, we wanted to file last week.
All right. Thank you, Senior Counsel. We'll take those into consideration. I want to go to something else because we are not going to exhaust that issue now. We will be retiring to give appropriate directions, but we have had the general drift of Counsel. I want to move into something else regarding the directions.
It's important, Your Lordship.
Yes.
I just want to have my learned friends here that the records of appeal are in form of soft copies, which can only be accessed by way of Google Drive. That means that even for the respondents, we must have internet throughout to do that. The capacity of our machines is also not that good. So then if the appellants can be directed to some hard copies to us, because that makes work easy for us to even peruse through the records of appeal and try to find out whether they're complete and whether we need to put in any supplementary records of appeal. So I would ask them to supply us with hard copies. Their clients are well endowed in terms of resources, thanks to taxpayers' money. So we can have that. so that we're able to produce proof without with ease of reference.
But look, I would want to clarify something, because the method of service that is now being complained about is actually set up by the High Court. And even the email service threads that are there were set up by the High Court. There was no complaint then. All documents in these matters have all been served online. And it was agreed with the direction of the judges then that the Deputy Registrar of the High Court would set up that mode of service, and it was set up by the Deputy Registrar of the High Court. It is the same method that we have been using even since we came to the Court of Appeal.
May I say something, Madam?
Yes.
I would like to emphasize a word that I'm friend is going to refer to. Spend.
Spend.
Fair.
Fairness.
Yes.
Mm.
We have to be fair to the parties. I support holding my understanding, Mr. Dade, and support my understanding, Mr. Mugabe. Speaking on behalf of the Human Rights Commission, for the Sharia, we have to be fair to the parties. Some advocates have just come in this month. They don't know what the whole matter is all about. So it will just 14 days or 10 days, it will not be doing fair. I would suggest to your Lordship very strongly that 21 days would be very fair, so that everyone is in the picture. But if we try to hang up the whole thing, we may find that some people within the court will think they have not received that fair. Let us be fair. 21 days is not 2 months, and the paperwork from what I've seen are giving us 21 days is fair.
Thank you, Senior Counsel. Mr. Kanjama, we will certainly consider all those views regarding time.
There was an issue that was raised relating to the intended appeal that we have filed a notice of appeal, and I wanted to address the court very briefly on that issue. Because what is happening is that under the rules of this court, there are 14 days after the judgment is issued to file a notice of intended appeal. That period expired on 27th of May. On 27th of May, there were 2 other notices of appeal that have not yet been converted into memoranda of appeal. Under the rules of this court, there is also 7 days after filing a notice of appeal to serve the other parties. That period expires tomorrow, on 3rd of June. Even though on behalf of the 75th proposed respondent, we have already served our notice of appeal. So the parties are deemed to know what it is we intend to appeal against. And that means that we have time from the time we served the notice of appeal to prepare our records of appeal. Under the rules of this court, we have 60 days. But we are saying, in order to expedite the process, if those appellants who already filed records of appeal can serve us who have not been served, and we can be exempted under Article 159 from having to prepare our own records of appeal, so that we only file memoranda of appeal.
Mr. Kanjama, we heard you on that, and it's recorded, and so I think...
So the last thing I wanted to say, my Lord, is that also under the rules of this court, when one receives a record of appeal, one is given time to peruse it, so that if there are incomplete sections, there are documents missing, you can file a supplementary record of appeal. So we think that in the timelines that the court provides, it should give the respondents as well an opportunity to confirm whether the records of appeal are complete and to file any supplementary record before the submissions can be filed. That is all.
Thank you very much. Thank you very much. We will give appropriate directions, and thank you for all the views that you've expressed on the issue. Now, on the length of the submissions that you are going to file, I want us to agree on that. Ordinarily, we say 12 pages, but I realize that is very limited for this kind of matter. Can we limit it to 20-25 pages? Can we limit it to 20-25 pages? Reasonable submission. We're going to allow each council to address the court to highlight the submissions if highlighting is deemed to be necessary, knowing that the amount of time that we are going to be upon, if it's 20 minutes, if it's 30 minutes, even if you are a party is represented by 3 council or 2 council, you should. So we want to hear on that, so that as we retire, we give comprehensive directions. Length. Let's start with the length of the submission.
The length we are requesting 30 because
with the length of the submissions.
The length of submissions we were requesting 30 pages because on the part of the Attorney General, he's the only party who is dealing with almost all the issues which are being raised, and therefore it will require quite substantial submissions.
On our part, my Lord, we require 20 to 25 pages.
Yes.
My Lord, IBC is happy with 20 to 25 pages.
Yes.
My Lord and my ladies, we require 30 pages. The reason being that the 2 appellants that we represent are affected by nearly all the issues that arose during the petition. We're in the almost exact position as the Attorney General, but I think we are a little bit more in every aspect of the case. So 30 pages.
All right, thank you.
My ladies and my lord, I think an average of 30 will do.
All right, thank you.
Most of the respondents, unless there is
thank you.
The only slight addition, my lord, is that as the respondents will be responding to 4 appeals raising different issues, some of issues of course are shared, and therefore we may require maybe slightly more than the pages that each of the appellants would require. I'll pray for that into 40 pages.
Sorry?
I'll pray for that into 40 pages.
Okay.
On our part, my Lord, 30 pages will suffice for submissions. I also intend to make a small application to be allowed to adduce further evidence under Rule 29 of the Court of Appeal rules to introduce the joint report of the National Assembly and Senate. But it is key to our petition, because one of the issues that the court will be asked to look at is whether we had a legal framework to conduct debates and referendum in the country. That report captures most of the sentiments. The reason why we were not able to produce that during the hearing in the High Court was that by the time we were hearing the petitions, the process at the National Assembly was still ongoing, and judgment was delivered after that report had been produced. So I do not think there will be any objections.
So it will be to introduce the what? The report?
Yes, the report by the Joint Committee of the National Assembly and Senate. And the answer that it is key to our petition and the appeal as well.
Okay. Thank you. That's all as far as time is concerned. We have had the range. We will give appropriate direction. And the issue of time, the time that we are going to allocate for making any necessary oral highlights. Senior Counsel, Mr. Roy?
I had suggested 4 days, each side to have 2 days.
And yes, but I want us to cap it in terms of minutes. Missions and looking at the authorities, we all have an idea that you will require so much time. We can limit you. We will have this timer adjusted accordingly.
I do think that one, on the respondent side, there are so many respondents, and I think allocating time will be a problem. As we have 4 parties, and I do think 3 hours.
Sorry?
3 hours.
For the appellants, all of them?
No, each of the appellants.
For submissions that have already been filed and exchanged?
I think the issue being dealt with here, very interesting principles, it will help the court for the appellants to clarify the submissions. I don't think there will be that understandable merely one.
At the risk of digressing, almost all of you have appeared for presidential election petition. How much time? Almost all of you have appeared before the Supreme Court in the presidential election petition. How much time are you having?
When I appeared, I was given 3 hours.
Yes, the same for us.
3 hours.
3 hours.
And how many how many were you in total as counsel? Was it every counsel 3 hours, or it is only the ones who had who are playing very critical, or rather representing the petitioners and the respondents?
No, it goes like this, when you're in the Supreme Court in a presidential petition, you get about 3 hours, and if you want another member of your team to address the court, you share that. So I believe Madam Fendi is suggesting strongly that each party gets 3 hours. If a party wants 2-3 advocates to talk, then that can be shared between the sides.
You know, thank you, I hear you, but you know, we have an average of 12 advocates or so.
Can I say something?
12 times 3 hours. You see how much time we're talking about? And then there's a replies and so on. We do not, we want to be fair, we want to dispose of this matter expeditiously, but we also want to do it in an orderly manner. We cannot sacrifice merit at the altar of expediency, no.
Yes.
Justification in maybe the appellants having a little more time, but the respondents, really, I don't see any justification of saying they should also have the same time as the appellants, because they are not all dealing with all the issues.
Sorry, just hold on. There's something.
Now, in comparison with what goes on before the Supreme Court during the presidential elections, that is an original jurisdiction. They are dealing with raw material. Here, we already have a judgment. We already have the pleadings. And what our plea to you is, you are aggrieved variously. Now, assist us to understand what is it that you are not happy with or happy about the judgment of the High Court. The background information is there, the pleadings we have. If you can direct the major strength or focus on the core issues for us to understand, where did the High Court go wrong? Where did it injure you? And how do you want us now to bring out this? That is what we need. And speaking from my own experience is 30 pages, yes, and you are going to give 20 pages or 15 pages of that submission on the background. It doesn't assist us much. Identify the core issues, the grievances, and you are going to exchange documents from each other. What is it that so-and-so is raising? What is it that I need to chip in? So that your assistants understand the case and then address your concerns appropriately. That will assist us. 3 hours, it means now we are going to have to hold a hearing for almost 1 week or so, or you want us to be hearing anyway. We are open 24 hours and all that. Yeah, so assist us. Go straight to the core issues. It is not raw material, you already have it. And you can deal with the replies. If there are new issues coming, we are open because we want to do justice to the matter. Thank you, Mr. President.
Thank you, lady. Mr. Harvey?
In any case, how much time did you take in the High Court?
Mama Lady, that's a germane question. In the High Court, the petitioners were each given 30 minutes. The respondents, because they were responding to many petitions, were given more. I think they were given an hour. Now, in this case, as the respondents will be responding to a total of 4 appeals, it therefore makes more sense.
It will be consolidated into one. So it will be...
Then still it will be issue-based. And my request is this. The respondents be given slightly more time than their parents.
Which you suggest to be?
My suggestion was this. If their parents can each be given an hour, then the respondents be given an hour and 30 minutes. Because I'm trying to compartmentalize this time within the 3 or 4 days that the court has proposed. If we're to do longer, then we can't even manage it within those 3 days.
All right. And realizing that some of the issues are so cross-cutting that once a particular appellant or respondent has addressed that issue, it may not require so much time to say the same thing.
Yes, that's true. For instance, like for us, we want the basic structure, thematic area, which if we have exhausted, then we need not have it repeated. Similarly, if Tuma here has addressed the issue of the quorum of the IBC, we need not address it. And I believe in the course of the oral submissions, the court will guide us accordingly, so that we don't fear of and repeat what another colleague has raised.
All right. So now, thank you.
My Lord, you'd note that in the submissions you're restricting us to 30 pages. If you are not restricting us on the written submissions, then I would understand why we should get 1 hour. Unfortunately, looking at the judgment, there were nearly 23 declarations made by that court affecting our clients, 2 clients we represent, all those 23 declarations. And you are minimizing the length of the submissions. And there's the other very important issue that this matter, it's not just a matter for this court. The hearing of this petition will be done in the full glare of the public. People would want to understand why this court will make a particular decision. I will plead with you that this is a very unique case, it's a very special case, looking at the circumstances. And it is about our constitution. So I would plead with the court that if in an election petition, presidential, which is narrow to the question of declaration of the seat following a presidential election, and you are given 3 hours
for each party, and I've been in those petitions. In this particular appeal or appeals, there were 9 petitions in the High Court, each seeking very unique declarations or decisions. And I don't think on behalf of my client or clients that an hour with 30 pages submissions would suffice doing justice to this case. And the public would also want to understand.
What would be your suggestion there for senior counsel?
I would go by the original suggestion that was made by senior counsel, Mr. Oraro, that you give us 4 days. And 4 days for this court to give to this very unique case would not be asking too much of your lordships. That out of those 4 days, you give 2 days to the appellants. And you know, in the High Court, we had a little bit, we had less time because each respondent had a petition before the High Court. We had to respond to all those petitions. And then the other 2 days you give to the respondents. That is how it is done in the presidential petitions. And it works very well. Between us, we can then share those 2 days and make sure that we make out our respective plans within those 2 days. I would really plead on this.
And what about if there are more respondents than the appellants, as it is actually here? So far we have 4 appellants, and I think a number of, is it 10 or 15 respondents? Should it still be 2-2? Or because they are responding to more or less the same issues, you think the 2 days will still be sufficient? Senior counsel? No, just hold on.
Yes, because we are the ones prosecuting the appeals. They will be also responding to those appeals. So if they are given that, and normally this court normally would try to determine who are supporting the appeal or who is opposing. And you try to minimize their time if you're just opposing, and probably your participation in the High Court was just on one issue. There was a petitioner whose issue really was about the conduct of the president in respect of Chapter 6. It was basically one issue. And I think to that extent we can be able to organize ourselves. For example, amongst the appellants, the IBC their role is not going to be as extensive as, for example, the Attorney General and ourselves. So between ourselves, we can organize ourselves in such a way that Mr. Oraro probably can take 3 hours, and I probably can take 2 hours, depending on how we organize ourselves.
All right. As senior counsel, before you take your seat, you know, in these COVID times, we are limiting the amount of time we are spending sitting like this. It is not comfortable wearing these things for 2, 3, 4, 6 hours. What about if we enlarged the length of your submissions and reduce on the time so that there is so much that is covered in writing? You are able to say even stretch it to like 50 pages, and then you have like an hour and a half to basically highlight your well-written submissions, which are more exhaustive. I truly hear what you are saying. We need to do justice to this matter. But I think it is going to be very uncomfortable for all of us, whether we are sitting in this place or in a bigger space, as I will be saying in a little while, to spend 8 hours or 6 hours in a day putting on masks, being confined in a tent or in a courtroom like this. The presidential election petition and other matters have been done in what I may call COVID-free days, when the court can sit even up to from morning till evening at night. We really don't want to be in this kind of setup for too long a time. Yes, Mr. Kanjama, we'll come to you.
My Lord, if I may just refer to what Lady Justice Nabuye mentioned.
Yes.
And to say that I have been with senior counsel Rengo in the Supreme Court on an election appeal, not an original election matter, gubernatorial. The Supreme Court would typically give 1 hour maximum for submissions, even with very voluminous record of appeal and submissions filed by the parties. My Lord, I would like to add that because this is a constitutional matter, it's a matter in rem, interests of parties cannot be easily sliced and diced and categorized as either supporting or opposing. There is a lot of jurisprudence in the judgment, so that the idea of giving a block of time to appellants and a block of time to respondents does not respond appropriately to the fact that each appellant and respondent may have different views on the various matters. Thirdly, because of the rules of this court, even if a party in the High Court was focused on 1 or 2 points of argument, once the judgment has been issued, a party in the Court of Appeal, by filing a notice of cross-appeal or grounds of affirmation, will be interacting with the entire judgment. And each party may have different views. So that the appropriate direction should be focused on each party, whether appellant or respondent, receiving roughly proportionate time, because they each need to deal with the various issues according to the instructions of their respective clients. And I do support the suggestion by LSK President Nelson Harvey that each party should not have more than 1 hour. 1 hour roughly, they will determine how to use that time. That is all.
My Lord, may I make a suggestion?
Yes.
I think I agree more with my President, Mr. Nelson Harvey, because the additional power that we get in the main arguments, the respondents will claim it back in reply, so that in the interest of quality of arms, each party ends up having 1.5 hours. That's my suggestion.
All right, thank you. Any other view before we leave that issue? Dr. Thiangolu, then, oh sorry, okay, you're on your feet. It's okay. Okay.
He says I can go ahead, my Lord.
Yes.
My Lord, while still on the issue of time, I think for me the considerations are as follows. Number one, this is arguably the most important litigation of our lifetimes. I've had comparisons with the presidential election petition, but if I had my senior Jimmy Orengo, this is about the Constitution of Kenya, and it's about the posterity of Kenya. So in my view, although there is a genuine case for limiting the time, we shouldn't box ourselves into a corner that says it is 1 hour, it is 2 hours, as though what is at stake is the time and not the future of Kenya. So if the petitioners, or rather the appellants, want 3 hours, in my view, subject to an equality of arms, it is not too much to ask, in my view, for a case that is arguably the most important case of our lifetimes. The only thing I would suggest, my Lord, I think that the reason we're having all this back and forth is we have boxed ourselves into the 3 or 4 days that the court gave as an indication. And I would urge the court to consider, is it possible to have, say, the 3 or 4 days in 1 week for the appellants and 3 or 4 days in the next week for the respondents, and then a direction that says those 3 or 4 days, the appellants must go and conference amongst themselves and know how to share the time, and in the other week, the 3 or 4 days, the respondents will conference amongst themselves and communicate to the court how they plan to share that time. I know, of course, this court is very stretched in terms of its human resources, but then again, it must be recognized that this is arguably the most important case that will ever be argued in our courts in our lifetime. As regards the physical space, Again, I think it's a matter where we can be flexible. The state has no shortage of resources. I was just whispering to my senior, Paul Mong here. We have even a facility here at KICC. We can set up a temporary code there, gazette it specifically for this, and then we can assuage some of these concerns about, you know.
I will address that in a little while. Just limit yourself to the issue of the time, then I'll come to that.
So, my lord, I was saying 3 or 4 hours that they request, they're just 4 appellants. To me, it's reasonable, given the magnitude of what is at stake. It's about how Kenya is governed in the long term. The only right there is, if you give them the 3 hours, then be mindful to give us, as the respondents, an equal amount of time that is fair. Remembering we'll be responding to all of them, not necessarily to one of them, even if the cases are merged.
All right.
Can I say something, Madam?
Yes, Dr. Mino?
Yeah. Madam, I do appreciate what you have said about wearing masks. It's very uncomfortable. I find it very uncomfortable. I would suggest that the best way out of this is to increase the number of pages that each party can submit to 20 pages or 30 pages, you could probably increase it even to 40, and then you are able to shorten the time you are directly in the court. Perhaps I may add, my lord, it's not only Kenya that's interested in this judgment. In fact, from what I've heard and seen and so on, the international community is very much interested in this case. They would like to see what you wanted to say and so on. So it's fair that we are, each party is given enough time to be able to address you exhaustively. And the only way we can get out of this problem with the COVID around 13 all of us is to allow us to put in more pages, probably 40 pages or even 50 pages, and then we can shorten the number of hours or the number of things to address.
All right, thank you very much. We are going to...
With your kind permission.
Yes.
Yes, my name is Edgar Busiega. I just wish to go on record that I support what my colleagues have stated, particularly Doni Yankolo, to the extent that parties ought not to be limited with time, such that time becomes the factor as opposed to the Constitution itself. Having said that, I'll urge the bench, to, when giving directions, to consider giving sufficient timelines of filing submissions, given that
Thank you very much. Lastly,
my Lord, on behalf of my client, we wish to request for an equal and fixed time. In terms of days, that would be very amorphous and not capable of control, so that we have equal opportunity. We request fixed time, and we suggest for 2 hours for the respondent and 1 hour and 30 minutes. We request for fixed time, and suggest for 2 hours can be compensated in this for the respondent.
All right.
And
thank
1
you.
hour.
Okay, I want to deal with another issue.
For the appellant.
Unless
and
it is very important,
can you compensated in this case?
Yes.
I believe it's important for them to also get probably equal time to those who have appeals. Because in the cross appeal, there could also be additional issues I may need to cover, therefore need equal time as the appellants.
We forgot those who are on the screen. Mr. Olochir, there was, I don't know what here. Was there anyone who is raising any issue? Are you hearing us?
Yes, Your Honor.
Okay.
Now, basically, I'm in support of the duties presented by the President Nelson Harvey and Charles Kanjama. We can have 1 hour maximum. As a compromise, I agree with the suggestion. We can probably add more pages for the written submissions, but we don't need to spend too much on the oral highlighting. Thank you.
Anyone else? All right, thank you. Thank you. We have heard your views. We will take them into consideration as we give directions shortly. Talking about the issue of how the hearing is to be conducted and the space. One, there will be a bench of 7 judges to hear the appeal. And so you can see that we cannot fit 7 of us here and keep the COVID-19 protocols. So we need a bigger space. And arrangements have been made to pitch a tent within the court premises outside the Chief Justice's gardens with the permission of the Chief Justice. If we agree that we are going to do this matter in that way where there is physical appearance, there will be adequate space for counsel and for judges. But we can also agree that we conduct the hearing virtually. I know from the correspondence that I've seen from most of you, and we know it, there are challenges when it comes to virtual hearings. Connectivity, sometimes Wi-Fi may not be working. We are not able to hear one another well. So I want to quickly hear your views on that before the court makes a final decision. Of course, today we are doing it in a dual manner where we are here, others in a seated courtroom next to this courtroom, and there are many Kenyans who are following it from the comfort of their rooms because we have sent out a link. May I quickly hear your views regarding the mode of hearing that we should have? Senior Counsel, Mr. Oraro.
On the part of AG, we suggest that we have a physical hearing, and with the permission of the Chief Justice, we can proceed with the idea of having that hearing in the 10,000.
On our part, physical hearing, and I think on the part of the premises proposed, we're quite happy with that space, this arrangement.
Okay.
We agree with what the senior counsel has said. Physical, in-person hearing.
In-person hearing.
Virtual hearings are not.
Sorry? Sorry?
Virtual hearings are not hearings for
Okay.
My Lord, we are happy to associate ourselves with the sentiments of our colleagues.
Okay, in-person hearing, yes. Yeah.
And we are equally happy with the directions. As part of the request we had made through a letter, so we are happy with the physical.
Thank you. In person, okay. Any other alternative view?
My lords, my ladies, I like the approach we've adopted today.
Yes.
I think you may find that because the hearing is going to take a substantial period of time, some of the parties may want to have the option, especially when they are not scheduled to address the courts, to be present virtually. So I propose a hybrid hearing where the parties who will be addressing the courts can preferably be present physically, and those who, other parties who want to be present physically, but the parties also be given the option.
Yes.
Especially because the hearing will take a long period of time.
Yes.
To occasionally appear virtually. So the way we have set up today, we set up that way for the main hearing. That's my proposal.
All right, thank you. Any other suggestion?
Yes, my Lord, I think we should go throughout the way Kajama is suggesting. The only thing I would add is that we should take care of the pathways, because you don't need to be a prophet to know that when that time comes, there will be very many people logging in onto the virtual platform. And from the experience in the airport, there was a lot of struggle because of the traffic. So I think the administrative officers of the court should have done it.
Thank you for that suggestion. All right, I think that is sorted, and thank you very much. We have said that about the number of...
Can I ask a question to the council? How would you feel if some of the 7 judges decided to hear the matter virtually? Because of the same concerns.
Judges will be sitting at home.
In their chambers.
And others from.
Yes.
And maybe you mean that some of the judges will be sitting at home.
In their chambers.
And others from.
Yes.
I think that we leave for the judges to determine on our part. I think we'll have no issue.
The only problem I say is that as I have seen or experienced, there are all respect for problems. Can you hear? Can you hear? The English more. Whereas if we come from the school here, we can dispose of this matter.
All right.
The only problem with that is when there's an issue, the judges would want to make a matter may arise in the middle of the proceedings, and if any number of judges are not in person, it can get pretty complicated. You need to consult. But when you sit in person, it's easier, even within the court, for quick consultations and answers that.
Thank you, Senior. Thank you, Senior Counsel.
And my Lord, it may be out of order, but there's a question of perception that may get out there if some of the judges are present physically and some of them are present virtually. Even the public interest in this matter, I would not be surprised if there's some citizens there who would think that the judges who are hearing virtually are not actually present and whatnot. I think it's a small sacrifice that we can make. In any event, I think how the court will view the race, the judges are in a fairly well isolated area from the rest of us. So I would suggest if it's possible, all the judges should be physically present, just because of the optics of administration of justice.
All right. Yeah. Sorry, just hold on. Just hold on.
Yeah, so the hybrid arrangement is not going to be new. We have already touched base with it, and what we normally do in such a situation is that we have an in-house arrangement for consultation. We at John go and consult with those who are around and those who are far. The situation that we find ourselves in, especially for those who are falling in the vulnerable age group, is of concern to all of us. And as you are aware, there is no hardware or a spare part for a human body. So we address the concerns of each and every person. We are open. Those who are willing to come and appear the way we have appeared, fine. And whoever we want and stay, I will say we use the way we have been reaching out to some of the advocates who are appearing before us online.
Tower Sacco offers you an opportunity to invest at a minimum of 20,000 for a term of 3, 6, 9 and 12 months at competitive interest rates. Open a fixed deposit account and start a journey of investments. Tower Sacco, a basket for all your financial needs.
Salad vegetable cooking oil is the clear-flowing secret to tasty meals. Buy 5 liters of salad vegetable cooking oil today and get 250 grams Zesta tomato sauce for free. Iflo kama salad. Salad vegetable cooking oil. Available in all cooking outlets countrywide.
Jina langu naitwa Esther Jerry. Napenda kutumia tunukiwa sana. Na inatumia kwa kupigia customers wangu, kuitisha vitu sokoni.
Wakenya wengi wanaendelea kuzawadika kila siku kwa kutumia tunukiwa. Piga *444# ili utunukiwe leo.
For years, others have told our stories and taken our narratives. That has led to misconceptions, half-truths, and outright lies. That ends now. It starts with the truth, our truth. A collection of our ideas, thoughts, and aspirations. The ones that propel us, enable us, and ultimately empower us. Find it all at nation.africa. An informed, unbiased, and comprehensive coverage of news and events with in-depth investigative pieces as well as opinions from the